Hello, everyone. My name is Darren Joseph from HTJ.tax, and we're a team of cross-border tax advisors that seek to demystify the sometimes confusing world of international tax. And today we have the honor and the privilege of having an in-depth conversation with Senor Jose Aguilar-Shea. Jose, would you like to introduce yourself, please?
Of course. Thanks a lot, Darren, for the opportunity, and obviously happy to chat about the Spanish Texas. So I'm a tax partner in international firm Squire Patton Boggs, based in Spain, in Madrid, Spain, and obviously was very used to working with international private clients, moving to Spain and planning ahead. So I hope we can make a useful conversation to anyone looking to move to Spain or having cross-border issues.
Fantastic. Appreciate it. So generally speaking, a way of, let's say, mitigating the wealth tax is to hold these foreign assets in a structure, generally speaking?
Yes, when the beneficiaries of such structures are not
in Spain. Gotcha. Okay.
And just, I mean, to make the story brief, but the fact is that the way we've tried to face this, we've had a lot of discussions with the tax authorities. Spain just doesn't recognize this trust. And to be frank, they deem that the trust as an abusive historical situation where, again, now I think nowadays they're trying to understand that trusts are just estate plan succession planning. It may not have anything to do with trust plan, with tax plan. It's just a succession plan. So the way we can structure that is the way that we can consider that we pull out these structures out of the person, the individual, and we pull it out of the wealth tax filing for that purpose, right? Because from a Spanish tax perspective, we can consider, let me put it this way, from a pure civil perspective, that the ownership is not within the settler. So we can work around the trust structure to understand where, from a pure civil perspective, what the tax authority says that we do not recognize trust, which this means that the ownership is at the level of the settler or at the level of the beneficiary. So what we try to do, build from a civil law perspective, is what is the concept of ownership, right? So we go to the civil law and say, well, we have to determine whether the ownership is in the level of the settler or the beneficiary. Something that from an Anglo perspective, it doesn't make sense because we're claiming, no, the ownership is with the trust. But that doesn't work in Spain. So we're trying to say, when we don't have one of the parties, who are we trying to attract the property from a Spanish tax perspective? To the beneficiaries or to the settler? So that's where we kind of able to work around these rules in Spain.
Okay, so but generally speaking, a trust is looked upon as an abusive structure, and
that was more the historical structure. Now I think we're commonly, it's not used by Spanish families yet. It's not a common, but again, I mean, international movement, the globalization, we have a lot of families coming through. So, I mean, so that's no issue. And again, we do have CFC rules, which, as you understand, they're demallocation of income. And that sometimes are penalized because they have a higher tax rate. But since trusts are purely tax transparent, the trust income would be directly allocated as capital income. So that could work. I mean, we can live with them. It's just that it would, but usually it's not something that a Spanish resident would set up. It would be something that would be planned ahead in the, let's say, the source country where the person is coming from, right?
So if you're a 6, 7, or 8-figure investor, entrepreneur, or business owner who needs a tailor-made solution from a qualified team of professionals, we can help you achieve the international lifestyle, the freedom, and even the tax savings you're looking for. Visit us at htj.tax and live that international life.